Judgment in the matter of Totel Ltd versus Commissioners for Her Majesty's Revenue and Customs.
Lord Briggs will explain the decision of the Court.
This appeal is about the European Union law principle of equivalence. Generally speaking, the EU leaves it to each member state to decide upon the procedures which have to be followed within the state for the enforcement of EU rights. The principle of equivalence requires that those procedures must not be less favourable than the procedures for the enforcement of comparable domestic rights. This does not, however, mean that procedures for the enforcement of EU rights have to be as good as the most favourable procedures for the enforcement of domestic rights. This is sometimes called the no most favourable treatment proviso, but it is really just an aspect of the principle of equivalence. VAT is an EU tax, and so appeals against an assessment to VAT are claims to enforce EU rights. In the UK, such appeals are subject to a pay first rule. That means that the taxpayer has first to pay the tax assessed before he can appeal, unless he can demonstrate that doing so would cause him hardship. The same pay first rule applies to appeals against assessment to many UK taxes, such as insurance premium tax, landfill tax, climate change levy, and aggregates levy. But it does not apply to appeals against assessments to income tax, capital gains tax, corporation tax, or to stamp duty land tax. The appellant Totel wished to appeal a VAT assessment, but could not demonstrate hardship, so it had to pay first. Totel claimed in the Court of Appeal that this pay first requirement offended against the principle of equivalence because it did not apply to appeals against assessment to the major UK taxes which I have just described. The Court of Appeal decided first that those taxes were not truly comparable with VAT, so that the principle of equivalence could not be applied, and secondly, that even if the principle could be applied, the no most favourable treatment proviso stood in Totel's way, because there were a range of purely UK taxes, which I've just described, in relation to which the pay first requirement applied to appeals. The Supreme Court has unanimously decided that the Court of Appeal was correct on the first of those grounds, so that the second question about the meaning and effect of the no most favourable treatment proviso does not arise. If it had done, this Court might have needed to refer that question to the Court of Justice for a ruling. But Totel's appeal is therefore dismissed. I give the only judgment with which my colleagues agree. The main difficulty with the application of the principle of equivalence to any particular procedure for the enforcement of EU rights lies in deciding what, if any, procedures for the enforcement of purely domestic rights are truly comparable. The Court reviewed a number of EU and UK authorities in order to understand how this task should be carried out. Much depends upon the level of generality at which the comparison should be made. At the highest level of generality, all tax appeals might appear to be comparable. At a more granular level, appeals about each type of tax might not appear to be comparable with any other type. The principles which emerge from the authorities are these. 1. It was not part of the purpose of the principle of equivalence to inhibit member states from framing bespoke procedural rules for particular types of claim, whether based on EU or domestic rights. This is a very common feature of national law, reflected, for example, in different limitation periods for different types of claim. 2. There needs, therefore, to be a careful focus on the particular aspect of the procedure in question alleged to be unfavourable, in this case the pay first requirement, to see whether there existed a connection between that aspect of the procedure and any relevant difference between the underlying rights. 3. The search for a comparator needed to be context-specific, with a focus on the purpose and essential characteristics of the allegedly comparable claims. And 4. There was no rule that VAT appeals could never be comparable with any other type of tax. Applying those principles, the Court concluded that for the purpose of the principle of equivalence, VAT appeals were not truly comparable with appeals relating to income tax, capital gains tax, corporation or stamp duty land tax for the following reasons. 1. Although there are exceptions, the paradigm VAT appeal is made by a person, usually a trader, who or which is, in economic terms, collecting the tax for the revenue, whereas the economic burden of the tax falls upon the consumer. 2. By contrast, the taxpayer in the supposedly comparable UK taxes is not usually a collector, but the real payer upon whom the economic burden falls. 3. There is a real connection with the tax collector status of the VAT registered trader and a pay first requirement as the condition for an appeal. And 4. There are exceptions on both sides of this comparison. Some VAT is payable without being collected from someone else. Some income tax, for example PAYE, is paid by a person, the employer, who may be described as a collector. But these exceptions are not enough to disturb the contrast between the paradigm cases. In passing, the court rejected the submission of the Inland Revenue that the pay first requirement was not less favourable than the procedure for tax appeals which did not contain that requirement. Viewed from the perspective of a taxpayer who could not demonstrate hardship, it clearly was. But since the UK taxes relied upon by Totel were not true comparators, there was therefore no infringement of the principle of equivalence in the imposition of a pay first requirement on persons wishing to pursue an appeal against assessment to VAT. And the appeal was therefore dismissed.
Thank you. The court will now adjourn.